Welcome. I'm gladdened by the number of our residents who've come out. My name is Mike Detmer. I'm a board member of PTP. PTP has been around since 1980 in different senses and numbers and people involved. But I really want to welcome you to this dialogue. We're going to have Holly Hillier, who is one of our lawyers, make a presentation and talk about a little bit of the past, where we are now, and where we're going. I am going to make the big assumption that we're going to have a civil dialogue here, and that we all are neighbors, and we all have maybe different views of what's going on and what's been going on. But in saying that, I also want to thank some of the trustees who are here. I won't name you. Some of the Planning Commission people are here, and they're tireless workers. That's my view of watching them in action. Far better than they get paid. Let me say it that way. The other thing I would like to say, I want to be clear that we want to talk about transparency. We want to talk about how to move this case forward towards settlement. But while we're doing it, and this is mainly for our financial supporters, that we intend, and I think the township board intends, to move forward expeditiously in the appeal. In any litigation, and I've been a lawyer 55 years, trial lawyer, and you have the court movement forward and you have the private settlement movement forward. You're always trying to find common ground to resolve a dispute. So while we're here to find common ground, we also want to make sure everybody understands we're moving forward with the appeal. With that, Holly, I turn it over to you, and after Holly's done, we'll be happy to take questions, whatever. And also, let me say this, and I don't know if it's at the end of the presentation, but I have my email on here.
Yep. And
I'm more than willing to have you email me, and if you want to sit down and have coffee, you want to have group discussions, you want to know what's going on in this case from PTP's perspective, I'm more than happy to meet. And I have met a number of residents I did not know previous to this, and I'm happy to involve myself as much as you would like. So thank you for coming. It's really appreciative. Holly?
All right, thank you. Welcome everybody, and I'm just going to jump straight into it because I want to leave as much time as possible for questions at the end. This is a short agenda, so you know what we're doing. We're already done with the first point. The second agenda item, I'm going to do a little bit of level setting. I want to make sure that we are all on the same page about certain zoning concepts and some vocabulary words that I'm going to be using. I'm going to be using some legal terminology and some zoning terminology. And while I know this is a pretty sophisticated group and that you're all fairly familiar with the litigation already, I want to make sure that we're all on the same page and that you understand when I use certain terminology, how I'm using it, so that hopefully we understand each other better. Then I'm going to review just a quick history of the wineries on the peninsula and talk about PTP's settlement principles, which I think many of you probably have already seen. I will have copies up here if anybody wants to take a copy when they leave. And then we're going to spend most of tonight answering questions from you. I'm going to keep an eye on time and hopefully get through this in about 20 minutes or so. But if you don't get to ask a question, we've got index cards and some pens up here. So if you want to write your question down, we can review those later. You're also free to email Mike. Where did you go? There you are. His email is on the last slide, and so you're free to email questions, and maybe it would make sense, depending on how many we get, to publish a follow-up to this or even have another conversation. So, definitions. When I talk about the wineries, most of the time I'm going to be talking about the winery plaintiffs in the litigation, the 11 winery plaintiffs that filed the lawsuit against the township in 2020. When I talk about a winery, in the zoning sense, I'm talking about a facility where wine gets made. Most of us, I think, we understand wineries as the sort of front-facing winery operations where we get to go and enjoy wine. In zoning terminology, that is a tasting room. So that is the space where you try and buy wine. And this is probably what most of us think of when we think of wineries. So 7 P words, Ps of zoning. First, this is kind of a bonus P, the purpose of zoning and where zoning comes from. The township's authority to zone comes from state law. In Michigan, it's the Michigan Zoning Enabling Act, or the MZEA. And what it says is that a local unit of government may provide a zoning ordinance to regulate land development by districts. So there are lots of purposes here. The 2 I want to highlight are that the use of the land is situated in appropriate locations and relationships, and to promote public health, safety, and welfare. That is why we have zoning. And this is what can happen in communities that don't have zoning. This is Houston. Some of you may have heard about this. This is a jurisdiction that has nothing more than a 50-foot setback requirement. So other things that zoning can protect people from, and that things that have been in the news lately, are things like data centers, gravel pits, things that you may not want to live next to. So this all goes back to that purpose of promoting and protecting public health, safety, and general welfare. So the first P, zoning starts with a plan. Starts with what is here our community plan, or our master plan. The township has had zoning master plans going back, I think until the 80s. Here's the 2011 plan and the most recent 2024 master plan. This P is really important, and it's going to play into some of the reasons for our settlement principles at the end. Zoning is permissive. Zoning does not say what you can't do, it says what you can do. And this is a little different from how we often think about law. We think about criminal laws that say you can't trespass, you can't steal, and if you do those things, you get in trouble. Zoning says what you can do based on where you are. And if a zoning ordinance doesn't say that a use is allowed in a district, it's presumed to be not allowed. Now there are like caveats to this, right? Not every single thing has to be enumerated, or else zoning ordinances would be a billion pages long. So there are primary and accessory uses. Primary uses are the main purpose for the property. So in a residential district, it might be houses. Then you've got accessory uses, which are sort of usual and customary things. So in a residential district, it might be garages, swimming pools, sheds, those kinds of things. And so here's a quote and a chicken. The chicken is there because this case, Pittsfield Township versus Malcolm from 1965, was just affirmed by the Michigan Supreme Court and the Michigan Court of Appeals in a case that involved backyard chickens. There was a question about, in a zoning residential district and a zoning ordinance where nothing was said about whether or not you could have chickens in your backyard, was that permitted or not? And so the Supreme Court in Michigan recently affirmed that under an ordinance which specifically sets forth permissible uses, absence of the specifically stated use is regarded as excluding that use. So that's the chicken case. One of the challenges with this litigation is that the zoning ordinance provisions that the wineries challenged were permissions. So here's an example. This is Chateau Chantal's dining room set up for a wine and food pairing dinner. Those were permitted under a provision, 8.7.3 10U2. This was the provision that allowed guest activity uses, and guest activity uses included the wine and food pairing dinners that we've come to know and love at Chateau Chantal. The district court invalidated that and a few other provisions. So now we have a big question. What can Chateau Chantal do going forward? What can any winery that had guest activity uses do going forward with those provisions invalidated? Another provision that was invalidated, two actually, there were the provisions that allowed the wineries to sell promotional merchandise. So logo tees, which, you know, everyone has logo tees. So what can happen going forward? Where did those retail permissions go? How do we figure out what the wineries can do in the future? I think this is P number 3. Zoning is based on place. Zoning says what you can do based on where you are. When we think about zoning ordinances, we think about mostly the text, but zoning ordinances have two parts. There's a map and there's text. And so it'll say, you know, in a residential district, you can have houses, schools, and parks. In an ag district, you can have farming. Typically, as you go kind of up, I guess down on my list, you can have all of the uses that were allowed in the previous district. So you can have houses and schools and parks in an agricultural district, but you can't have farming in a residential district. It works one way. In a commercial district, you have hotels, shops, and restaurants. And so here's a couple zoning maps that are probably very familiar to you. Here's Peninsula Township on the right with the green representing the agricultural district. Yellow is coastal residential. And there's a little, I don't know if you can even see, let me try my laser pointer. There's some commercial in the middle there. And here on the Traverse City map, you've got a very large commercial district. Still, again, a lot of residential. And then you've got like some hotels here. You've got the airport, which is very unique. And what you'll notice is that zoning is very unique to the shape of the land and the jurisdiction that it covers. So these maps look totally different because the land is different. And this is also kind of a bonus P. Parcel characteristics matter. So this is Bowers Harbor here. Bowers Harbor has some unique characteristics to its parcel. It is landlocked. There is, I believe, a landfill on one side, a road on another, a neighborhood on another. There's a park, and so there is no more land for Bowers Harbor to expand into if it wanted to farm more acreage that's contiguous to the land that it has here. For a winery chateau special use under the zoning ordinance, the old zoning ordinance, you had to have 50 acres. And so Bowers Harbor had to get a variance to excuse it from that minimum acreage requirement because it was off by about 4 acres, but it was landlocked. And so that's why zoning takes the nature of land into consideration. Sometimes there are things that you just can't help because of the shape of your property. Here's another example of parcel characteristics. This is Bonobo and Black Star, and both very unique parcels in that they're on PDR land or purchase of development rights land. So here's one of the conservation easements. That completely changes what can happen on those parcels. Black Star is also interesting because it took over an existing building. My understanding is that it used to be a fruit processing facility before Black Star came into the property. So again, really unique properties here. And so this is the pig in the parlor case. A nuisance may merely be a right thing in the wrong place, like a pig in the parlor instead of in the barnyard. And so zoning is about where things happen. And so, you know, restaurants, I think we probably all think restaurants are universally great things. I am hoping to go to one tonight when I leave here. But we don't necessarily want restaurants in every place in a community. So next P, zoning requires a permit. Some uses in a district are by right. Some uses are special uses. Most of the wineries have special uses. I think 9 out of the 11 are special uses. And special uses are designed to allow some practical latitude while providing a procedure and provisions for protecting the health, safety, and welfare of the public. Back to that purpose of zoning. The general standards in the Peninsula Township zoning ordinance consider the unique characteristics of the proposed location for a special use. And the use has to be harmonious and appropriate not change the essential character of the area. The board has the ability to impose conditions and safeguards if it's concerned that the general welfare or individual property rights might be impacted by a proposed special use. And one example of that is over at Mari. So you can see the red circle here is a neighborhood. Mari's our red dot. This is their special use permit from 2016. Specifically in that special use permit, the board considered the proximity to neighbors and found that there is only sufficient buffering to allow for a maximum of 50 attendees at guest activity uses, and that those uses should take place indoors. So this is maybe, to me, the most important P. Zoning is a public process. The process to adopt the master plan is public. The process to adopt or amend a zoning ordinance is public. The process to apply for a special use permit is public. And here in Peninsula Township, that means that there is a public hearing. There are two. There's two layers. There's one before the Planning Commission and one before the Township Board. Sometimes there's more than two. So there's lots of opportunities for the public to get involved and provide input. And here's an example. This is from 1998. This is when Peninsula Sellers proposed converting the schoolhouse here on Center Road into a tasting room. The remote winery tasting room zoning amendment proposal was debated for a long time. There were several meetings about this, and a lot of people had a lot of things to say because there was concern that putting a winery right on Center Road could lead to having basically a convenience store. This would be a great location, for people to stop at and buy snacks and beach towels and sunscreen and other things as they're driving up to go to the lighthouse for the day. So there was a lot of debate over whether or not that location was appropriate. The other thing that's unique about this particular winery is that its winery, so talking about that facility from back at the beginning where wine gets made, not the tasting room, its winery is several miles away and kind of off the beaten path before the wine trail was part of, became part of the peninsula. A lot of people would visit the wineries that were easy to get to, but not go off the beaten path so much. So they wanted their tasting room to be located here. And I think as we move forward, it's also important to remember that not even all of the winery owners necessarily agree on what's an appropriate use in the ag district. Mr. O'Keefe here, representing Chateau Grand Traverse, mentioned at the time that he had concerns that remote tasting rooms should be located in commercially zoned districts and not in the ag district. So there are a lot of different opinions, and that's why the public process is so important. I think this is my last P. Zoning is perpetual. It runs with the land. It's a lawyer term. So what it means is that it doesn't change. Like if I'm living in a house that has, a very small setback, and the setback requirements change while I'm living in my house, I don't have to move my house. I can sell my house to somebody else. They can buy it, and they don't have to move it either. These are called non-conforming uses. So the zoning amendments are going to change the ordinance over time, but whatever permission you get generally stays the same going forward. Changing the zoning ordinance doesn't automatically amend the permitted uses for a particular property. So this is another issue that we have to solve with this litigation now that the zoning provisions that were at issue in the lawsuit are mostly repealed or replaced by Amendment 201 in 2022. The big question is, what non-conforming uses do the wineries have left? So here's an example. Here's Chateau Chantal's bed and breakfast and the inn at Chateau Grand Traverse. The winery chateau ordinance was repealed in 2022, but that doesn't mean that these facilities go away. So here's a quick history of wineries on the peninsula. I'm going to see how we're doing on time.
I think it's fine.
I'll try not to take more than another 10 minutes or so here. So in 1975, Chateau Grand Traverse was the first winery established on the peninsula. In 1989, as a result of a proposal by Chateau Chantal, the winery chateau special use was created. And in 1990, both Chateau Grand Traverse and Chateau Chantal got special use permits under that provision. In 1992, Bowers Harbor came online, so to speak. They did not have a winery chateau. They had a roadside stand and a unique special use permit under a provision of the zoning ordinance that doesn't exist anymore. So 1998, that was the Peninsula Cellars Remote Winery Tasting Room Special Use Amendment. A few years later, you get Amendment 139, which added the farm processing facility, which is a use by right. This is interesting. This is the only use by right, which means as opposed to a special use where you have to go before the Planning Commission, go before the Township Board, and have that public hearing process. This is an administrative process. If you meet the minimum requirements, fill out an application, and you can obtain a use by right. So Bry's, in 2004, got a permit as a farm processing facility. They eventually became a winery chateau. That was also the same year that Amendment 141 was enacted. That was the amendment that created guest activity uses. That was that came about because of some litigation between Chateau Chantal and the township, that Chateau Chantal wanted the right to do some more expanded activities, and that was what became guest activity uses, which eventually many of the wineries here got those added to their special use permit after the fact. Two Lads and Black Star became farm processing facilities in 2007. In 2013, Bonobo and Hawthorne. Hawthorne was a farm processing facility until very recently. Just before the litigation, actually, they obtained a special use permit for a winery chateau. Mari started in 2014, Tabone in 2016, and then in 2022, you have Amendment 201. And so none of the zoning provisions that gave rise to any of those wineries are part of the zoning ordinance today. So all of these guys have non-conforming uses of some kind, and no two wineries are the same. So several have permission to host those wine dinners, those guest activity uses. Not all of them do, even though they have the permission in their permits. Some have bed and breakfast facilities. 2 of them host weddings for their overnight guests. 2 are on PDR land. 1 has a variance, we talked about that earlier. 1 has some special retail permissions and outdoor functions, and 1 has the tasting room that's located separate from its winery. And why is that? That's because they've all applied for different permissions. So we've got a special use permit application, a farm processing facility permit application, and a special use permit amendment application. If somebody wants to amend a special use, they have to go back before the Planning Commission, and some of these wineries have done that multiple times. I think Bry's is maybe on their 4th amended SUP. And so now you've got wineries that look very different from one another. There's a few. And so that brings us to PTP's settlement principles. Principle number 1 is that we support winery-specific terms, and we oppose amending zoning. We support expanded land uses that are tailored to each of those 11 wineries' unique characteristics. And we hear the call for fairness among the wineries, and I understand that it's difficult to understand, I think, like why one winery gets to do certain things and another winery is also a winery but doesn't get to do those things. So we support creating more consistency, but there needs to be a balance with respect for how each winery's particular setting impacts its neighbors. And we also support uniform and enforceable noise standards. And we support winemaking and wine sales as the principal operations of wineries. So generous retail wine sales and tasting, indoors and outdoors. Most of the wineries have, at the very least a patio, if not, a very extensive outdoor tasting area. Generous retail sales for promotional merchandise, even though those provisions have been invalidated. We have no problem with wineries selling logo T-shirts, and the key here, of course, is that it's balanced and that the principal use is winemaking and wine sales. all the existing food service. All the wineries have food service. Most of them have charcuterie boards. Some of them do soups and little pizzas. They all, frankly, sound like they have amazing food. Three of them maybe have commercial kitchens, but we would not support adding any commercial kitchens to those that do not already have them. Free activities and entertainment in the tasting room. A lot of them have been doing this for years. You know, things like music, trivia night, things that get people through the door. And we support traditional hours, which I believe here, you know, generally like 11 to 7 in the evening, but with later summer hours negotiable by winery. And we support expanded revenues through agritourism that's directly tied to winemaking. This is Chateau Chantal's Grape Harvest Festival, I believe. This is their grape stomp. You'll see some people are barefoot. This is super cool. I believe this might be a free event, but this is the kind of event that we think, you know, if the wineries want to have limited events where they charge a fee to promote the winery, that's something that we would be happy to negotiate as long as it's tied to winemaking. And again, you know, the food and wine pairing dinners, you know, the capacity, the frequency and duration of these things would be something we'd have to negotiate, the hours, especially if they're close to a neighborhood. But again, like, no facility rentals for private parties, wedding receptions, conferences. The key here is that these are winery driven. These are events that the wineries would want to have to promote their winery and not things that third parties want to use their facilities for. And we support settlement that results in better compliance. Improved voluntary compliance would be ideal. Like, we would love to see the wineries, we would love to see them have some buy-in into a settlement agreement where they are agreeable to the terms and there's no enforcement necessary. If enforcement becomes necessary, we think it needs to be consistent. And we also acknowledge that over the years, there have been some inconsistencies, and I think that's created a sense of unfairness. So clear terms and clear understanding of what everyone can and can't do to support consistent enforcement if it's necessary. And our last principle is that we support negotiations conditioned on complete taxpayer relief from damages. No part of the $50 million damages award should be collected from township property owners.